Well, good morning. Nope, it's not good morning. It's good afternoon. It's 3 o'clock. And today is September 23rd. Welcome in. My name is Sheila. We are in the what are we in? We're in Crime Time with Sheila. I think kind of working on dropping that rubber Ramada in here. We'll leave that for the fun and crazy stuff, but Crime Time with Sheila. We'll go with that. So with that, Denise and I have been scurrying in the background. We're going to do the closings for Arlene Alvarez today because they've come back with a verdict yet. It hasn't been announced, but we will watch it together. I have it pulled up. I have it paused, so we won't have, we're going to watch this together. So, it's been a kind of crazy day here for me. So, we're going to do this. Let me pull up the screen. If you don't mind, hit the thumbs up when you come in. I got to learn to tell people to like the stream. I'm not used to that. So we're going to skip jury instructions. And let me change this. Different screen. I don't like this screen for streaming this. See, it happens when you're picky. It just happens. When you're picky, it just happens. And I wasn't set up. I got too excited because I was like, oh my gosh, verdict is in and we're not even finished with closing yet. So we're going to jump over and we're not going to listen to jury charges. We're going to jump straight in to. All right, here we go. Oh my Lord, what is wrong with that sound? Hold up.
Good afternoon, everybody. What the judge just read to you is...
Let me check the KHOU stream and see if that was any better, because I didn't look at this and I did not know it was going to be that horrible. Hey, Cindy. Good morning, love. Let's see. KHOU. Let me see their stream this morning. Let's see. Closing arguments here. Yeah, theirs is better. Here, hang on.
You will receive this form with y'all when y'all start deliberations. Each side has 45 minutes. The state of Texas is opted to go first and then go last since it is their case.
Okay, so each side has 45 minutes. I'm going to boost the sound because y'all know we all be deaf in here. So we're going to boost the sound, turn this down a little bit. And they got 45 minutes each. And let's roll. I'm excited.
When you start speaking, I'll start my timer, sir.
Thank you, Your Honor. Good afternoon, everybody. What the judge just read to you is called the jury charge. He's going to give you a copy of it. But essentially, it's the law in this case that's going to apply to your deliberations. And then each portion or section of the law that's explained in here has what we call an application paragraph. It explains how you apply the facts and the evidence that you've heard during this trial, whether it's testimony or video, and how it applies to this case. So it's just guiding you in your deliberations. And we're going to talk about the charge here in a moment. I mean, it's 21 pages long. You guys sat here for a bit while we were reading it. We'll talk about it here in a moment, but first I want to talk to you about...
I'm actually going to mute and be quiet because I take notes because I'm a writer. I remember things better when I write. So a lot of times y'all see me looking down and it's because I'm writing. I'm taking notes. It's to help me remember things. So I'm going to mute though, because I don't like talking over when they're doing closings or, when we do sentencings and the people get up and give their last, wording. So a makeup tutorial. So I don't, makeup. Man, you got me scrolled right there, Cindy. But yeah, I don't like talking when they do a lot of that, putting their feelings out there. All right, let me shut up. I'm babbling. Okay, we're going. I'm going to be quiet though. I'm going to mute.
A couple of things. When I'm done speaking, the defense will have the opportunity to speak to you, and then you will hear from Mr. Jordan last. That's because the state has the burden of proof. So the law says that we talk first and then we talk last. But one of the things I wanted to talk about before we get started is We've heard a lot of testimony over the last couple of days. The law is complicated, but it's actually pretty simple. Why? Because look at your fellow jurors around you. Each one of you has a different profession. Each one of you lives in a different part of town. Each one of you has a different background, but every one of you is a member of our community. Every one of you is a member of Harris County. And together, the 12 of you, the 14 of you even, represent our community. The one thing that we're asking is don't leave your common sense at the door. Don't leave all the things that you know in your gut and your instinct tell you at the door. Apply the facts to the law, but don't leave your common sense at the door. The next thing I want to talk to you about is the law itself. Okay? The defendant is charged with the offense of manslaughter. A person commits the offense of manslaughter if the person recklessly causes the death of an individual. This is on page 6 of your jury charge. The question is the defendant aware of a substantial and unjustifiable risk, and does he consciously disregard that risk? Because here's the thing, ladies and gentlemen, no one in this courtroom is going to dispute that he shoots into a car and kills Arlene Alvarez. Not a single person in this courtroom is going to dispute that. They're just going to ask you to find that his actions and conducts are justified. They want you to believe that her death, his actions that caused her death, are justified. So the question is, when he gets out of the car and he shoots at the robbery suspect in the back 3 times, we know it's not self-defense. Their own expert testified to it yesterday. You have to be immediately necessary to perceive the unjustifiable use of deadly force. The guy's got his turned away. We'll get to self-defense here in a moment. The question is, when he is shooting into the car, shot number 4, shot number 5, shot number 6, shot number 7, shot number 8, shot number 9, shot number 10 down the street, is he aware of the risk that he's going to shoot and kill somebody in that car? Absolutely. Is he aware when he takes shot number 4 and he takes shot number 5, is he making a conscious decision to disregard that risk? Absolutely. Your common sense tells you that. You don't need a homicide investigator to tell you that. You're watching him do it on video. Mr. Jordan made a very specific and clear point to you guys. You're a unique jury because we can't take you to the crime scene, but we sure did bring it to you. And we'll go over that here in a bit. The next question you have. So first is his risk. Is there a substantial and unjustifiable risk, and did he consciously disregard it? If the answer is yes, he is guilty of manslaughter. Now, this reckless injury of an innocent third person, it's on page 7 of your charge, okay? What this law says is before you get to self-defense, before you get to defense of a third person, before you get to defense of property, you have to answer this question. And you will see that that is exactly how it's laid out in your charge. Is he guilty of manslaughter? Did he recklessly kill an innocent third person? If the answer to this question is yes, you don't go to self-defense. If the answer to this question is yes, there is no defense of a third person. If the answer to this question is yes, there certainly isn't defense of property. And that's what the law says. Before considering whether the defendant is not guilty because his use of force was justified by self-defense or defense of property, you must consider whether those particular justifications are available to the defendant. So even though a person is justified in threatening or using deadly force against another, if in doing so, if he's justified and he's using deadly force, he recklessly injures or kills an innocent third person, self-defense and defense of property are not available in the prosecution for the reckless killing of an innocent third person. So you don't even go to self-defense. You don't, before you consider defense of a third person, before you consider defense of property. If the answer to that question is yes, if shot number 4, shot number 5, 6, 7, 8, 9, 10, he's consciously disregarding a very unjustifiable and substantial risk of shooting into a vehicle and killing someone, he's guilty of manslaughter. And there's a reason why this is on page 7, because if you get here and the answer is yes, you move to the back page and you sign the verdict form. That's why self-defense is on page 8. Your answer should be yes, and you should not move to page 8. But let's just say, because we know that they're going to get up here and argue, in voir dire, they're not required to tell us what their strategy is. In voir dire, they're not required to tell us if they're going to put on evidence or not. They're just not. The law doesn't require objection. You have the burden of proof.
Shifting, objection, striking a defendant over shoulder of counsel.
And remember what I said.
I forgot to tell y'all, the little bit that I did watch, yes, it's spicy. It is spicy. I'm going to back up just a second.
Defendant over shoulder of counsel.
Because we know that they're going to get up here and argue. In voir dire, they're not required to tell us what their strategy is. In voir dire, they're not required to tell us if they're going to put on evidence or not. They're just not. The law doesn't require objection. You have the burden of proof.
Shifting, objection, striking a defendant over shoulder of counsel.
And remember what I said, I probably have this memorized, the statements by the attorneys, including opening statements, closing statements, evidence. Evidence comes from the witnesses and also from the testimony that you have heard. You may continue, sir. And my rule is always that you can't go past.
Sorry, Judge.
It's okay. Just a friendly reminder.
We have the burden of proof. We have the burden of proving to you beyond a reasonable doubt that he is reckless when he shoots into a car that he can't see into. We have the burden of proof that he loses sight of the robbery suspect, and then Alvarez's truck comes down the road, the next thing catches his eye, and he's just unloading into that vehicle. Now, the reason why in opening statements Mr. Jordan told you the perspective that matters is the defendant's is because that is how the law of self-defense applies. The perspective that matters isn't the China Star video across the street where you can see the assailant running by the Alvarez's car, because he wouldn't have seen that. Their own expert told you that. He wouldn't have seen past the chase sign. So the perspective is certainly not when the robbery suspect is running down the street and he has his arm stuck out, right? Because the defendant wouldn't have even seen that. The defendant, as it pertains to self-defense, the question is there a immediately necessary reason to respond to the use of unlawful deadly force to prevent the other person's imminent commission of an offense, to prevent the imminent commission of an offense? So, look, Mr. Taravella, their own witness, admitted it. When the robbery suspect has his back turned, not self-defense when he shoots shot number 1. We all know in Texas, you can't shoot a person in the back and then claim self-defense. You just can't.
That's a misstatement of the law.
No, it's not.
The law is in the jury charge. Refer to your jury charge.
I'm not muted, sorry.
If a person is running away from you after they've committed an offense, you can certainly shoot at their back to get your property back, but you can't shoot at their back and use deadly force unless you're presented with the imminent use of deadly force. Their own expert, I asked him very specifically, first shot, self-defense, yes or no? Nope. Second shot, self-defense, yes or no? Nope. Third shot, self-defense, yes or no? Nope. Fourth shot, self-defense, yes or no? Oh, wait, the fourth shot, the one where in State's Exhibit 108, that video we compiled, remember that one? We talked about it with Zachary Caldwell. You guys remember that video? That video shows you the sound frequency of shot number 4 is the same exact sound signature as shot number 1, as shot number 2, as shot number 3, as shot number 5, as shot number 6, shot number 7, and shot number 8, and shot number 9. Their own expert said shot number 4 sounds exactly like every other gunshot that man fired that night. You don't need a homicide detective to tell you what it sounds like. We know what they're going to get up here and argue. They're going to say, CSU could have collected more shell casings. Mr. Jordan told you that in opening statement. He told you what we're going to present to you. He told you they didn't find 10 rounds, but beyond a reasonable doubt, you will know he shot 10 times. Their own expert admitted it. He told you they found the casings next to the grate and a couple next to the ATM, and that's exactly what the evidence showed. He told you that the trajectory at which the gunshot is fired is perpendicular to the vehicle, and that's exactly what the experts testified to. They called Andrew Taravella, a crime scene reconstructionist who sat on this stand right here and didn't testify to anything that Chelly Rossi testified to, our reconstructionist, but instead went to a field he's never been certified as an expert in, never testified as an expert in, and wanted to comment on a surveillance video that was compiled by an actual licensed digital forensic analyst. Notice how I kept asking him, you keep saying that those tapping sound is gunshots, but you keep using the words, I believe they're gunshots. Are they gunshots or not? And his response was, well, I can't say that they're gunshots. Regardless of the fact, the defendants already started shooting at the back of the robbery suspect. Regardless of the fact, when he sees a vehicle coming down the roadway and the windows are up and the vehicle is tinted and he cannot see a firearm at that moment, we know he's not in fear of deadly force being used against him. He's the one that's running into the middle of the grassy area and shooting at a car that he can't see into. We're not asking you to leave your common sense at the door. You guys are reasonable. What would a reasonable person do? You guys are reasonable. Don't leave your common sense at the door. What would a reasonable person do? And it's not self-defense from the perspective of the defendant. No. The law specifically says a reasonable belief means a belief that an ordinary and prudent person would have held in the same circumstances as the defendant. This is why this is important. In opening statements, they told you the robbery suspect and Tony Earls exchanged gunfire. That's what they told you. They told you that when Tony Earls gets out of the vehicle to pick up his keys, he gets shot at. Not true. The video evidence tells you that. It's just not true. He gets out of the car and he lets off 3 rounds in the direction of a man that's fleeing with his back turned to him. And you can tell that from a surveillance video. Same way you can tell he shoots 10 times. You don't need 10 cartridge casings to tell you that. We watched on the video. State's Exhibit number 108. Go back in the back, watch that 3 times, start your deliberations. You won't spend too much time past page 7. But here's the thing. Self-defense is from an ordinary, prudent, reasonable person in the circumstances of the defendant. Not the defendant, but an ordinary, reasonable person. So then the question becomes, okay, well, is he trying to get his property back? Because I asked Mr. Taravella that. Well, shot number 1, the law in Texas does allow you to shoot somebody in the back as they're fleeing away to get your property back. Shot number 2, he's justified in regards to defense of property, not self-defense. Shot number 3, defense of property. Definitely not self-defense. Definitely not past page number 6, if you believe that there was a substantial unjustifiable risk and he had a conscious disregard for that risk and he killed an innocent third party, you don't even get to the self-defense questions. But let's talk about shot number 4, shot number 5, 6, 7, 8, 9. He's trying to defend his property by shooting into a vehicle that you can't see into. Don't leave your common sense at the door. Shot number 10, he points his firearm, and their own expert actually said it. He points his firearm as the vehicle is moving. He's already dropped his phone and his keys and picked them both back up. He's now in a moving vehicle. He opens the door of the vehicle. He sticks a gun out, and he shoots into the middle of an intersection, dropping his phone and his keys that he just picked up. And I asked Mr. Taravella, he shot into the middle of an intersection. And their own expert said, actually, I don't know where he shot. What do you mean you don't know where he shot? You said he went to the crime scene. Is there an intersection after that frame or not? He said, yeah. I was like, the reason you don't know where he shot is because he could have been shooting at Armando Alvarez as he's standing outside of the car. He could have been shooting at the vehicle when it has its brake lights stopped, flashing in his direction. And then he peels off after shooting and he goes in the opposite direction. They want you to believe that it was reasonable and he was trying to get his property back.
Mind you, the property was $20. And I believe a wallet.
Before you get to self-defense, before you get to defense of a third person, before you get to defense of a property, if you believe beyond a reasonable doubt that there's a substantial and unjustifiable risk that if you shoot into a car, you're going to kill a person, especially if you can't see into it, or he has the conscious, objective disregard for that risk when he turns that gun on gunshot number 4, and Armando and Wendy Alvarez are looking at this man shooting into their vehicle on the way to go get pizza with their 9-year-old daughter in the backseat. He's guilty of manslaughter. And if he kills an innocent third party, if you believe he killed Arlene Alvarez because he was reckless about the way he's even handling the firearm that night, shooting with one hand, jumping around, you don't go to self-defense. You don't entertain defense of a third property. You certainly don't entertain defense of a third person. Don't leave your common sense at the door. The 12 of you are reasonable. The 12 of you are members of Harris County. And at the end of closing arguments, you're going to start your deliberations. And in one voice, you will render one verdict that is one word: guilty.
May I proceed, Your Honor? Just look at this thing. Give me 1 second. 26 minutes and 25 seconds left. Give me 1 second. Let me start the timer to show. So I'm a little confused. You wanted me to do 3 reminders?
I'm sorry, Your Honor. What were you asking?
You wanted to do 3 reminders? What is it? How much time do you want?
I just want to give me like a minute at 9. I'm just want
Oh, okay. You just want to get
that's all. 10, 11. I'm not.
I'll tell you when you're used 10 minutes and then
That's
just
fine.
switch.
Judge, I just want to make a few points here.
Okay, go ahead.
Good morning, ladies and gentlemen of the jury. Listen, I was thinking this morning about what I would say to you, and I'm going to start out because I knew this was coming. 42 years, 43, I've been doing this. These are seasoned, okay? Make no mistake about it. I was anticipating their theatrics, and believe me, there's going to be more to come. Raising your voice, pacing, ranting, raging, that's not evidence in the case.
But sir, that's exactly what you're doing right now while you're saying this. I know I said I wasn't going to talk, but oh my gosh. Oh. Okay, calm down, Sheila. Take a breath. Look, what did he just say? He says, we're not going to pace around. We're not going to raise you. And I previewed just a couple. I turned this on to make sure it was still going on earlier, and they get loud.
And believe me, there's going to be more to come. Raising your voice, pacing, ranting, or aging. That's not evidence in the case. So I'm going to talk to you, something I typically don't do. I'm actually going to keep my voice down and kind of walk through a couple things I just want to encourage you to talk about when you're there, because Mr. Maroon, he talks about what he thinks the evidence is and how our client didn't do this and he didn't do that. So let me start out with, I want to turn on and talk to you about a couple of things. Remember when Rossi was on the stand and I walked up with the code and I asked her to review what a prosecutor's duty is? Remember when she agreed with me that the prosecutor's primary duty is not to seek a conviction? Okay, that's not the primary duty. It's to see that justice is served. And make no bones about it, Arlene deserves justice. Okay, she does. Thankfully, we know from the evidence in this trial that if and when they ever prosecute the suspect who started this whole series of events in motion, they have video of him. You saw him robbing Tony and his wife. You saw him running. You saw him jumping over a fence. At the very end, they put that up. Clearly, after all of this had occurred, you see this guy climbing over the fence, and they have a pretty good shot of him. I can't tell you how they'll prosecute that person and what arguments they'll make to his jury, but I can talk to you about the evidence in this case. And here's the thing. We talked about how you don't secret evidence. Okay, you put it all out there. You let the juries decide. And here's what I hope some of you want to get the discussion going on in deliberations, is that we spent hours and hours and hours of listening to them talk about the what. Well, we all knew the what. We told you the what up front. Tony shot into the truck. Okay? But we had to listen to angles. We had to listen to all the scientific evidence. But if you notice, what they brought you was people who either work for their office, okay, or someone who works for the Montgomery County's District Attorney's Office, okay? But we didn't hear from some critical people. And let's talk about that. I want to put the overhead up. Well, the first thing I want to talk to you about is, it was here, but it's that little USB that has State's Exhibit number 108 in it. Now, no, it's obvious through this trial that this is the techie. This man and Zach Caldwell, they are the techies. I don't profess to be a techie. I can't make digital exhibits. I'm the guy, probably the only person here who's still writing on a yellow legal pad. Okay? But if you recall, okay, Zachary Caldwell gets on the stand and they're going to play, I'm sure we're going to see it, it might be part of the theatrics, put it in slow motion and show the call-outs. Boom, boom. It didn't happen. It happened real fast. Now, I don't know if it's deliberate. Maybe it's an oversight. I don't know. Okay, I can't tell you which one because I'm not in their heads. And maybe they can just say Zachary Caldwell decided to leave out the 5 shots, and let's talk about that because Andrew was pretty straight up. Okay, for 35 years on the police force, he's heard gunshots. Okay, so he said he kept asking him, "Are they gunshots?" And he goes, "Well, in my opinion, I believe they were gunshots." Okay, and so as I walked back, I even pointed out that Rossi, their expert, the woman is an expert in almost everything, but she was still in the courtroom hearing that. And I said, basically asked them, get him repeated because they would have the ability to rebut with her. They could put her back on the stand. Here's what they didn't do, though, okay? Whoever did it, whether Caldwell or whoever instructed, whenever they talked about, they intentionally left it off the call-outs. And I'm calling them out on it because we showed you A, B, C, and D, if I can publish this, shows that the call-outs would have registered. And if you wanted to do an accurate compilation, then A, B, C, and D would have been on it, okay? Now, if you notice, we closed. They didn't call Rossi back. They didn't address the call-outs that they eliminated from that state's 108 exhibit. They could have called her back and she could have said, in all my years and all my experience and all my education, I think we heard about everything she did since kindergarten. But we stipulated she's an expert, and she didn't dispute the fact that those were gunshots. They didn't address it straight up, okay? Nor did they address it after the fact, okay? And so that is, it's kind of a misleading exhibit, okay? I'm gonna use that word. It misleads the jury. You know, you get to consider, and we've said it all along, you got to consider the why, okay? The why. And he made reference to, we don't need to bring a detective here. Well, let me show you a couple things too, and I think you should talk about, and hopefully someone will bring it up. And listen, a lot of the theatrics, and a lot of the walking around and the yelling and moving up close to the jury, you know, everybody here, they're good lawyers. I like to think I'm a good lawyer, okay? I'm going to try to keep my voice down, but, you know, they make emotional arguments to incite emotion. And if you get back there and you keep talking about the emotion, look, it's a tragedy, man. I can't even comprehend what it must be like for the family, all right? The foreman, whoever you are or she is, whoever becomes the foreman, it's going to be your job to say, look, we can't use prejudice or bias or emotion. Let's look at the facts, and let's look at all the facts, the totality of circumstances, okay, when we're deciding. So quickly, because I don't want to use all of it, but State's Exhibit number 23. Look, I think they even agree it was the worst, one of the worst investigations you'll ever see as far as collecting the evidence. I mean, he couldn't even identify these two guys in the suits that are talking there. We know from the facts in this case that the one guy on the left, if you can compare, look at his head, we know that he's the same person who interviewed Tony Earls, okay, in this exhibit right here. Here's Tony being spoken to by the detective. And Andrew said, 35 years I've been doing this, and it's not routinely we call a detective. So there's two things that they kept from you. They kept from you the detective's opinions of whatever they may have been from the case about what he felt, the guy who was out there that night, okay? And they're going to tell you, oh, they could have called him. Well, we don't have the burden of proof. They do. So look at it, look at the fact and consider the fact that that's, you know, something they kept from you, okay? And then the fact that our client gave a statement. He's interviewed shortly following this event. And here's what this shows you. I mean, you can basically see his demeanor when he's speaking to the detectives, okay? Now, you know, I think even Andrew or Rossi had said, we can't introduce our client's statement. Okay, we're not allowed. They can, they have it, okay? And what it tells you that it's what he's thinking because they're obviously talking about it. So here's what they kept from you, okay? And let me say this, you got instructions. The fact that they can't call him to the stand, and I can tell him whether or not to take the stand. I'm just going to tell you that, like the judge told you in the very beginning of the trial, there's all kinds of reasons. Packed courtroom, skilled, very skilled prosecutors. You could take all kinds of things into consideration.
Just to give you
I'm sorry, I have a few left.
For 10 minutes, you can take as much time as you want.
Okay.
You asked for 10 minutes.
I'll need just a couple more. So I think it's important to recognize that that you shouldn't just consider the what, you got to consider the why, okay? And part of the why is what he's obviously talking to the detective about. And so I hope that at least some of you are offended or moved by the fact that they kept this information from you. And you, I would encourage you, because he brought it up, use your common sense. If the detective had a favorable opinion to their case.
Objection, improper argument outside the record and false.
That'll be sustained.
Okay, well, Judge, I don't know what his opinion is. I'm just saying.
Because it's outside the record, he's not allowed to argue.
It's sustained. Please move forward,
Okay,
sir.
all right. So you don't know what his opinion was because they didn't bring it to you. You don't know what Tony Earls told them or spoke to.
What the fuck is happening?
While making Maroon
What is happening?
made an issue of it. And the language says you have to consider while making no effort to determine the identity of the occupants of the motor vehicle. While making no effort to determine the occupants, okay, of the vehicle. Well, so here's what you do. Rather than just using their graphics during closing, a boom, 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 and the stills that they did with Rossi, all I ask is you do this. Talk about the speed of the vehicles, and the videos have it for real. The sound out there, including what he tried to refer to, I think, as somebody packing their cigarettes. It's probably a statement he'd like to pull back on. The sound, the sight line.
Sir, he is a total train wreck in himself. Stop. Deep breath. Good Lord.
And the split-second timing and the limited lighting, okay? So when you talk about how you might have reacted or someone might have reacted, just look at all the facts, okay? As far as what he saw, we know he intersected the truck, okay? And his determination was started with being robbed, followed by the robber running in the exact direction of the truck, that going right up to the truck and the truck emerging, okay? So he had facts to make a determination, but he had to make he made a split-second decision. So I think that he's right about one thing. You probably don't get too far into this charge because of that issue if you consider all of the facts. And I can say it for Ed, I can say it for Anna. Actually, I want to say it for Mr. Earls, that I think if you consider everything, then in that instance, not just the watt and just the video, the stills of him shooting into the truck, that you should render a verdict of not guilty. Thanks, guys.
Mr. McLeese, as soon as you have 31 minutes and 25 seconds.
Judge, I will not be taking long.
And what kind of reminder did you want?
Oh, so they are separating out closing. They're each taking a little part. Okay. Don't see this happen very often. Are we going to play with his brain again? Talk about his amygdala sticking out there?
For this thing to get called up, it takes some time.
I pause your time.
Good morning. I'd like to start off by saying something that is obvious but needs to be said. And that is what happened to Arlene is horrible. It's tragic. It's every parent's worst nightmare. I don't wish that upon anybody. The Alvarez family did not deserve that. They do not deserve the pain that they're going through. Okay? We are not here to suggest otherwise. We never had been. I don't think you think we are, but that needs to be said. And you're about to be given a superhuman, Herculean task that's very hard to do. And that is to separate this tragedy from your duties as jurors under the law. Okay? You've got to put aside the heartstrings that they're about to get up and pull on heavily. All right? They're very good at it. They're going to get up and pull on that heavily. But I do think that when you look at the instructions that are given to you by this judge, okay, these instructions called a jury charge, 20 plus pages of instructions, your guidebook, okay, it's going to take you to the right result here, the just result. In this case, okay, you're not, let's talk about what you're here to decide, what you're here not to decide. You're not here to put a stamp of approval upon anything that happened. That's not it. You're solely here to decide whether or not the state proved beyond all reasonable doubt whether Tony was reckless that night from his standpoint. Okay, when we say reckless, we're also, and I'm going to go over this in more detail in a minute. We're not saying the word reckless like we might say if we're having a cup of coffee. Okay, it's a very specific legal definition that you're going to need to apply. Now, I've got a couple of things up here that we first visited about in jury selection. Remember, this is the presumption of innocence, all right? Maroon, Mr. Katani, like to talk about order of things in the jury charge. This is the first one, presumption of innocence. Your default setting is not guilty. And to get beyond that, they've got to prove everything to you beyond a reasonable doubt. Now, along with what Mr. also said, they spent a whole lot of time over a week dissecting, to use Mr. Jordan's words, frame by frame by frame of something that we've never really contested. And that is that the gunshot came from Tony Earls, okay? I wish it didn't, but it did. That's the situation that we're in. But what you need to look at, you guard against legal sleight of hands that are being done, okay? And it is not insignificant, the decisions that are made by prosecutors who are this experienced, to not include any investigators, any detectives. There were multiple ones out there. We heard about that. None of them came to you. Okay, they brought one first responding police officer to you. They brought a couple of the crime scene people to you. But think about what they did not bring, all right? That didn't make you wonder why? That's not by accident, okay? We introduced the crime scene video. They didn't. Why? Not by accident. There's a lot that they're wanting to take, to use the analogy Mr. also made earlier. They're in the replay booth trying to circle, receiver that may have been open and not considering it from Tony's standpoint with everything that he had going on. So let's look at the specific allegations, all right? And this is good. I took some bullet points here, but this is what it is. He's accused of recklessly causing the death of Arlene Alvarez by discharging a firearm in the direction of a motor vehicle. And then this is the weird one, while making no effort to determine the identity of the occupants of the motor vehicle. It's up to you to determine whether that constitutes recklessness. Okay, we are here to say that under these circumstances, it does not. We are not saying there's open season on shooting cars, all right? That's not our point. This is a very, very, very unique set of circumstances. So manslaughter is our charge, recklessly causing the death of an individual. This is where I think they failed, all right? This is where they failed. They have to prove beyond all reasonable doubt that Tony was aware of but consciously disregarded these risks. And I'm here to tell you, it's not just the risks of a firearm, okay? It's this specific set of circumstances, okay? How could Tony have known that given everything that went on here? This is a tragedy. It's a tragedy. But him being involved in this tragedy does not make him a criminal. This is where we start off, okay? They never showed you this picture. We had to bring it to you. Why? Because they don't like it. Because it humanizes Tony. He's just trying to make a deposit so he can go to dinner. That's all they're trying to do, and a gun gets put in their face. That's an experience I hope no one else in here has to go through. I can't imagine the horror. It's nighttime, and you're seeing your entire life pass before your eyes, and then it triggers, we heard Dr. Lambert talk about this, it starts to trigger chemical reactions in our body, all right? And it gives us, Mr. Jordan, very skillful cross-examiner, was trying to make it sound like you're either in fight mode, or you're in flight mode, or you're in fear. I'm here to tell you, as the doctor did, these all converge, okay? These all converge. This is a chaotic, terror-filled situation. All of these emotions, all of these things are converging, and Tony is reacting. He's reacting. He's not even, we heard about that, the whole frontal lobe starts to shut down. He is reacting to the situation. So we have at the very beginning, and I'm going to tell you, this is a fluid situation. At the very beginning, and they concede this, okay, when he's shooting, under Texas law, he is allowed to shoot at this guy, okay? He is allowed to. There's not any dispute on that any more than there's any dispute that Tony's the one that shot at the car, okay? These are things that are not in dispute. At that point, okay, they think that as we get to the vehicle, that Tony should have made an effort to determine the identity of the occupants of the vehicle, and that it was not reasonable for him to not do so. But what I'll suggest to you is when we look at the evidence, and look, y'all can get all of it. Look at it as much as you want. Okay, go through it. But you need to go through it. The law is instructing you. You do this from the actor's standpoint, from Tony's standpoint, all right? That chase sign, yellow circle, right? And this is what I was talking about. And this horrible constellation of events. You've got right as the robber is running, all right? He goes behind that sign, and it happened to be right when the truck is slowing down. It's not Armando's fault he was slowing the truck down. He's dealing with the same stuff everyone else is in this situation, trying to figure out what to do. We're not blaming him. But right as the truck slows down is the exact time that the runner's there. It's right behind that chase sign. It was, I am going to tell you, a reasonable thought for Tony to believe that that truck that was slowing down, you see the brake lights on right there, okay, that it was picking up the robber. And at that point, it became a threat. A threat where he is allowed to defend himself. Okay, because you can watch the video, watch the way the truck's maneuvering. Tony doesn't know what's going on. He is firing as rapidly as he can because he is in fight or flight mode. All right. His self-defense is presumed reasonable. This is on page 9 of your jury charge. Okay, if he knew that the person against whom force was used, okay, and he believes he's using against the robber, and I believe, and I'm submitting to you, that's a reasonable belief based on this evidence. He did not provoke the deadly force of the robber. No one's suggesting he did that. He was not otherwise engaged in criminal activity, okay? With that, there's a presumption there on self-defense. And I'm going to get to what Mr. Catania was talking about, the innocent third person here in a minute, but I'm going to preview here for you. Okay, all of this, everything we're talking about concerns recklessness. If the first definition you need to look at when you get back there is recklessness. Was he aware? Was he actually aware? There's a separate charge for when you ought to be aware. Okay, there's a separate charge. That's not what they brought here. They brought is aware. Okay, and once the self-defense issue is raised, and you'll read it in here, this isn't me, this is instructions coming from the court. Once self-defense is raised, they have to prove beyond all reasonable doubt that he did not act in self-defense. Okay, that's and it's been raised. So that is also on their burden. Not only do they have to prove that he acted recklessly, they have to prove that he did not act in self-defense. All right, so to prevail, they essentially have to say that Tony did not believe his conduct was immediately necessary to protect himself against the robber, and that this belief was not reasonable. All right, so this is something that they've done a lot of work, the prosecutors have, to try to minimize this. Okay, and one of their witnesses was even saying, well, I don't know if that's a gun. What do we do? Again, like I question with the witness, he ain't waving goodbye to Tony over there. Now, on this one, this particular shot, is Tony's view blocked? Perhaps, okay? But there's 2 times where we see him, where we see the robber with his hand back like that, all right? Once before that truck, once after the truck. And I'll submit to you that if he did it before the truck, he did it after the truck, he very well may have done it here when we're not able to see him, all right? I've never heard of the state giving so much benefit to an aggravated robber as they have in this case. And the reason that they're doing that is because we know good and well the robber should be in this chair. He's the most responsible. But they got to have someone that they can get a scalp from to give you. Reckless injury to a third person. Again, don't be distracted by this, okay? This is all if you do not believe that Tony was reckless, and we're telling you he was not, then this is irrelevant, all right? So for you to believe that he was reckless, you have to believe that he knew. He understood that after the stress of this event, when he's having a gun pointed at him, and he doesn't know what's going on, okay? And by the way, let me also say this. There's a lot of confusion as to whether or not he's being fired upon, all right? Armando was confused by that. Tony was confused by that. And I'll tell you, in a situation like that, I'm not blaming anybody except the robber. It is natural to be confused when your head is being flooded with such conflicting information. Okay? Again, from his standpoint, what he saw looked like the robber was getting in there. We know that the robber was at the very least pointing guns in the direction. All right? So with all this, we look at this with what we call the totality of the circumstance, and I'll tell you, they did not meet the burden of proof here. They did not prove to you beyond all reasonable doubt that Tony that Tony knew that this was going to be the result. No one thinks, and I don't think they're even going to say that Tony woke up that morning wanting to hurt anybody. We all know that. We're here because of horrible circumstances. A lot of people in the wrong place at the wrong time, and a robber who's not here. I'm going to turn over the floor to Ms. Funes.
You have 17 minutes and 40 seconds. 17:36.
This case starts with heartbreak. We've all acknowledged that. No one here thinks that what happened that day is not a tragedy. Tony doesn't think that that's not a tragedy. You have to separate emotion from this case. When you get back there, you have to separate emotion. You have to follow the law. Every time that you feel like emotion is taking over, because it's normal, it's natural. There's a dead 9-year-old. We all acknowledge that. We know that. We've acknowledged that every step of the way. Every time you feel that emotion taken over, we ask that you step back and follow the law. We ask that you remember the facts of this case. All the people that they've brought to you, I believe it was Mr. Caldwell. He said, I think the jury would benefit from pausing and slowing it down in order to better understand it. Well, guess who didn't get to pause and slow down? Tony. Tony didn't get to slow down and pause what was happening. He had seconds to make a life or death decision. Mr. Alvarez twice, under oath, said they were shooting at each other. He believed they were shooting at each other. That is what he saw. And Dr. Lambert said that is normal. His reaction is just as normal as Tony's reaction. It all happened so fast. Does that mean Mr. Alvarez was lying? No. What he believes he saw may have been accurate. It all happened so fast. It was traumatic for everybody involved. There was a gun pointed at Tony and his wife.
She's gonna put me to sleep.
They want you to forget about that. They don't want you to think about that because the robber's not here, because nobody has found the robber. Because the person who should be sitting right there is the robber. They reminded you over and over that you're citizens of Harris County. As citizens of Harris County, you should be demanding that the robber be sitting there.
But we haven't found him, ma'am.
I believe it was CSU told you, well, no, we didn't swab anything. The swabs are too expensive. So you have a robber who pointed a gun at a family, who caused all of this, a dead 9-year-old, and CSU comes in and tells you, well, no, we didn't swab. Swabs are too expensive. We heard that there was a Detective Farrell. Where is he? Why didn't they bring him in? The undisputed facts. They brought you people, like Mr. also said, who only got involved in this case a couple of months ago. This case has been going on for 3.5 years. They brought you people that would show you things slow down from their perspective, not from Tony's perspective, not people who were involved in the investigation.
Wait, chill, dude.
And Mr. Catania was very adamant about that last shot. When Tony gets out of the car and he says, well, he made that last shot as he's pulling out of the car, out of the driveway. Well, did he forget that he also showed us that video where the Alvarez family and Mr. Alvarez testified he's waiting at the street, down the street for Tony. You see his brake lights in the reflection. He waits 17 seconds. He's waiting down the street. And as Tony's wife is pulling out, they realize they're waiting on them. He then reverses.
Outside the record.
The jury heard.
That's what the video shows.
Statement Marshall, I'm giving you evidence comes from the stand. You guys get to believe who you want to believe. I mean, you may continue.
He reverses by his own testimony. He says he reversed. He then makes a U-turn and decides he's going to chase Tony. How is Tony not supposed to think that the truck is involved in the robbery? He thinks the robber's coming back for me. That's what that last shot is. The robber's coming back for me. I am in fear for my life. It's not this, I'm just going to shoot down the street. The robber's down the street waiting on me. That's what Tony believed. He said, I waited, I reversed. I made a U-turn and started chasing him. Call it whatever you want. He tried to say, no, I wasn't going to chase him. It wasn't a chase. It wasn't a chase. He chased him, and you see it in the video. Now, they each may have been erroneous in what they believed, but Tony thought the truck was involved in the robbery. How was he not supposed to think that the truck is involved when he gets out and sees him waiting on him? What else is he supposed to believe? Now, these 5 shots that Mr. Catani says, it's just somebody packing cigarettes. packing cigarettes. Well, you know who could have told us whether it was packing cigarettes or 5 shots? The detective. Why didn't they bring him? He would have answered that question.
Why didn't Mr. Tony Earls get on stand and answer any of those questions? Just curious, ma'am. Calm down.
So yeah, we're left to speculate whether it was shots or not. In his opening, Mr. Jordan said, Tony had a right to shoot the robber. He told you that. You don't change the evidence to fit the theory of the case. The evidence is what the evidence is. Twice, Mr. Alvarez said they were shooting at each other.
Ma'am, you're wasting time
And
being so
Mr. also
quiet.
said things that they didn't bring you. The detective, the CSU video that we had to introduce, and what Tony told them. When you get back there, you can ask for a readback of what Mr. Alvarez said from the stand. Now we watch the body camera. As soon as the police arrive on the scene,
I have no clue what happened. My screen just disappeared.
this angry person that Mr. Jordan would like him to be, he thought we were involved with the robber. See the brake lights. You see them waiting. Why didn't they bring you the camera from the front of the building that would have shown Mr. Alvarez's truck? All we have is a reflection. All the things they didn't bring you. But they want to make up for it with emotion. Yes, there's a dead 9-year-old. We know that. But you still have to bring the evidence. You still have to prove your case. You don't get to make up for it with emotion. We don't convict people based on emotion. One of you during jury selection said that's why he was here, because he believed in the justice system. We don't convict people based on emotion. We convict on the law. We follow the law. Based on the law, you must find Tony Earls not guilty.
26 minutes and 25 seconds.
I'm gonna set it up first.
You stop my time first. Never started.
Okay.
He was waiting down the block there. Y'all remember the testimony. What Armando said is he stopped his vehicle and got out and walked the back of the vehicle and checked on Arlene. That's what he was doing. Isn't it funny how all three lawyers told you don't base this on emotion? And then they all talked about emotion. They all want you to be emotional about this defendant. They all say, you got to feel what he was feeling. You got to understand what he was feeling. Ed is yelling. Anna is soft. And Anthony is accusing me of impropriety. But don't base your verdict on the emotion. Life is emotional. But if you notice, the evidence we brought you was not emotional. It was analytical and it was logical. We can't escape the reality of what this case is. Emotional for everybody. I want to address a couple of things that they said first. The law allows me to respond when they talked about not bringing the homicide detectives. And Mr. Oso suggested that they must not agree with the case. This is the way, and I'm allowed to say this as his response. This is the way this works. If any police officer or any homicide detective involved in this case disagreed with it, I'd be obligated ethically to tell them. And they would have brought him. So that is just not true. The reason why you didn't hear from homicide detectives is because this case wasn't a whodunit. Besides interviewing the defendant's wife, there's nobody else to bring you. They seized surveillance video. And so what we did is we brought you the facts in the case so you could know what happened. There's no better evidence than that. It's funny, they always complain about too many cops. Now they're complaining there's not enough. Y'all can know the evidence. I want to talk about this stuff. It's like they were saying, oh, well, you know, we're not disputing they shot in the car. Well, these are the shots. First, they claimed he shot first. Then they claimed the lack of muzzle flash was because the robber got some kind of special bullets. Y'all remember that, right? Well, now
This
we
objection
know.
mischaracterizes the evidence.
Same instruction, you heard the evidence, you guys can determine what the evidence is based on the testimony and the witnesses on the stand. You may continue, sir.
And now they still are going on the video from across the street. They did it again in argument. You see, they're crossing paths, so of course it's reasonable for them to think that he got in the car. Remember, what the law says is you're in the defendant's shoes, not in his mind. The defendant would never have seen them cross paths. We know that. He goes into the dark of night and he starts shooting into the next vehicle. But they keep showing that. So you start thinking that it was reasonable. And it was not. Maroon was right. This is actually very simple. Y'all can go back there, and the sole issue before you, is it reckless to shoot into a vehicle when you can't see in? Period. hard stop. That's the decision. And we all know that's the case. But don't base it on emotion. You notice what they do? They keep calling him Tony. Tony this, Tony that, Tony that. It's Mr. Earls. A 9-year-old is called by her first name. And it seems like she's kind of been absent from this trial. It's all about him. Let's talk about him. His wife was clearly fearful. At that moment, they were being robbed. They didn't know what was going to happen. We all know that. But he got out of that vehicle angry. He got out of that vehicle, make no mistake of it, and the law allowed him to do it, is he could have shot that robber and killed him for the property. But make no mistake of it. Y'all can start debating this back in the jury room. That man decided he was willing to kill somebody over a wallet, 20 credit cards, and $20. That's what was in his mind. He was already ready to kill. But then, once he does the shots, he doesn't get back in the vehicle and flee. He then goes to that open space, angry. And he starts shooting at the next vehicle. And that's the sole issue before you. Is shooting into a vehicle that you can't see in a reckless act? And we all know it is. We don't have to prove he knew Arlene was in there. If he knew Arlene was in there, he'd be charged with capital murder and would be facing the death penalty. All we have to prove is it's a reckless act. It's not justified to shoot into the vehicle when you can't see the occupants. You know, there's been some talk about this robbery suspect. There is a suggestion somehow that this robbery suspect is responsible for Arlene's death. And make no mistake of it, we would have loved to have captured him. But it isn't his actions. It's his actions that caused the death. And it helps you to know that that was rather probably not either a real gun, 2, a gun without bullets, or 3, if it was a gun with bullets, he had more restraint than anybody, because as he's being shot at, he's not sure.
Judge, I object. That's a mischaracterization of the evidence.
Same instruction, tired of repeating it, you heard the evidence. Testimony.
Judge, did you not look? It's even on the screen. Tired of repeating it, sir. Oh my, that all.
He's not sure.
Judge, I object. That's a mischaracterization of the evidence.
Same instruction, tired of repeating it, you heard the evidence. Testimony.
But that didn't matter to Tony Earls. To Tony Earls, it was worth killing. And he did not care. You know, we talked a lot during jury selection about guns in our community. And some of y'all on this jury are into guns, and that's a good thing. Some of y'all are not, but you respect those who do. And folks who carry guns, we all know there comes a responsibility when you choose to arm yourself. When you choose to purchase a weapon and have it on your person, you are responsible for your actions. And yes, the very laws that give you the right to kill to get your property back, the very laws that allow you to defend yourself, is also the very law that protects the Alvarez's family. Because you know there's a right in our community that we haven't talked about. There is a right for a family to drive in the Gulf Gate area to a pizza parlor. There is a right for a family to be able to drive down the block on Valentine's night. Have you thought about that? The day of love. And they're driving to dinner. They have a right to not have that man fire into their car because he's pissed off. Make no mistake of it. That man was not fearful anymore. That man decided he was angry and he was going to do something about it. And not only that, he was willing to kill everybody, even if he thought the assailant, the robbery suspect, had gotten into the car. Have you thought about? He was willing to kill not only the robbery suspect, but anybody he was in the car with. Have you thought about that? Because he didn't care. And you know that. Because after all that, when he's looking out and he sees Armando, he shoots in that direction. Again, jeopardizing everybody behind Armando and his family into an intersection. And they want you to believe that that was reasonable. They sold you that again. See, guys, if y'all just see that he's passing the car enough, even though it's not my client's perspective, maybe you'll believe he's reasonable. It's in his shoes and in y'all's mind. That's the difference. You don't get into his mind. His mind is angry and unreasonable. It is your
Objection,
mind.
that's a misstatement of the law.
You guys have the jury charge. That's the law in the case. Refer to it.
They showed you this again. Again, trying to affect you, but not the facts according to this defendant. I'm going to show you 108 again.
Again.
Because it is so important. And there was a suggestion that, yes, he did have a couple of seconds, but you know what? He didn't even think. He just started firing.
Since we have seen these videos, that was the clearest I have seen that shot from when he opened that door. I'm going to hit play again. I just paused because
There's nothing more powerful I can say or words I can string together that are more powerful than what you just saw. What you saw was not an accident. True, it's a tragedy. But a little girl is dead because of the actions of this defendant. And Maroon is absolutely right. When you read that charge and you get to page 6, it tells you that in the course of all this, if you recklessly cause the death of an innocent third party, you go to the verdict room. How else can you interpret this evidence? And it's a reasonable person's understand. The rest of you, had you gotten out of the car, you would have
Objection,
gotten
improper argument.
back in the car. It's a reasonable person standard.
Once again, you heard my instructions with respect to what they say not being evidence that comes from the exhibit and the witnesses. You may continue.
Judge, for that particular one, and we have a rule.
So we will, you have 7 minutes and 53 seconds.
It's a reasonable person standard, so you have to ask yourself, would I have even gotten out of the car? If yes, that's okay, you're justified. But after that, would you have gotten back in the car?
Objection, Your Honor, conveying the province of the jury.
Look at the charge, y'all decide. Sir, you understand the rules, please continue.
And
Judge, we have
lastly,
a ruling.
That is sustained.
you certainly would not have shot into a motor vehicle where you couldn't see into it. And if as a result you kill somebody, an innocent third party, you know you're responsible. We have talked this entire trial about Tony Earls. It seems like it's lost. That a child lost her life. Have you thought about what the interior of that truck was like as this was going on? I'm going to play you the audio, or we're not going to see anything. And as you listen to it, I want you to think about it. That when he is firing those 3 shots, he is firing at someone's back. I want you to think about when you hear shots 4 and 5, I want to remind you of Armando's testimony that when he turned the gun to us after the robber, I thought he was going to shoot Wendy and I. So then he speeds up when you hear the sound of his tires. Then you're going to hear 6, 7, 8, and 9. And when you hear the 7th one, you know that's the one that hits Arlene. Then there's going to be some silence. And you're going to know that's when he gets out of that vehicle to check on his daughter. But in that silence, I want you to remember what Armando told us. Everybody was screaming. Armando Jr. was screaming, "My sister's been hit. He's got blood all over him." When you hear that silence and whatever they're trying to say is 5 gunshots down the block, I want you to think about that moment. were armed with the law. Considering all of that, this should be the easiest decision because it tells you no matter what was happening out there, when you recklessly caused the death of an innocent third party, you're guilty of manslaughter. And can there be anybody more innocent than a 9-year-old child? She is sitting in that picture on Valentine's morning in the seat in which 14 hours later she will be dead. You heard the medical examiner tell us that she was shot above the right eye.
2 minutes.
And that the bullet fragments were in the back of her head. What we know from that is when Armando tells us she had her headphones on and he yells to his family, "Get down," she doesn't hear it. But there's a difference between someone yelling in a car and gunshots ringing and you can hear it. So she looks as they're passing and she's looking at the man who would kill her. She is looking at the man and the barrel that would cause
Objection,
her.
there's no evidence of that at all.
Sir,
How else do you interpret that the shot happened above her right eye as she's looking outside?
Excuse me, Your Honor.
Stop.
oh,
I asked
You have
the
an
jury
objection.
be instructed to disregard this last comment.
Disregard that last statement. You may continue. You have 2 minutes left.
You remember. This is why you were here. To put an end to this. And to finally hold this defendant accountable for his actions. And Moon and I now give it to you. Go back in that room and bring justice.
I read you the charge. You've heard arguments. Please go with the bail.
okay. Switch over. They're showing it is from 419 to, I'm sorry, it shows 4419 to 4724. So whatever the verdict is, it takes them 4 minutes to read it in. Yeah, that was rough. Okay. So we're going to watch the verdict. And with that, I get to play my verdict thing. I've never got to play this before. So here's our transition.
Adios and va conmigo.
Okay. So with that, we're assuming right, and they said disregard, no way. Oh, you see, adios and bye.
You may be seated.
Okay.
Who's the fourth person? Is there a verdict?
Yes, there is.
Thank you. You may be seated. Mr. Earls, please stand up. In cause number 1926763, State of Texas versus Tony Earls, we the jury found the defendant Tony Earls guilty of the offense of manslaughter as charged in the indictment, signed by the foreman of the jury, written by the foreman of the jury as well. Does any side wish the jury to be polled? Okay, you may be seated, sir.
They
Gentlemen, you may be
both
seated.
said no.
This concludes the first portion of the trial. The second portion is called the punishment phase of trial. And if I could have a minute and speak with the parties,
1
and
hour.
we'll let you know what the scheduling is. My understanding is someone has an appointment anyways, so it's best to start tomorrow anyways, so I can get everything that we need. So remember my admonishments with respect to
Wow.
speaking with, researching or speaking with anyone about the case. It's still jury trial, okay? So remember all that. And I plan on working tomorrow and hopefully resolving the case. So please make plans accordingly. Every party, okay? Everyone. Y'all have a good night.
All right, for the jury.
Okay, so they'll have penalty phase tomorrow. The jury went out at 1:30 to start deliberations. They came back at 2:30 Central. So it took them an hour. 1 hour to come up with this verdict. This man has no tears.
Y'all may be seated. Before we conclude for today, I'd like y'all to look at, y'all may be seated, the jury charge. And so my plan is, whatever punishment you have stayed, I'd like to conclude it all tomorrow. Whatever punishment you have defense, I want to finish all tomorrow too. I want to argue this case tomorrow and stay as late as we need to stay to get a resolution in this case. I know people have been waiting a long time. Okay? All right, I'll see y'all tomorrow. We'll
That's
stand in
how we
recess.
do things in Houston.
Judge, will they able to have a conversation with the jury? I just saw some of their faces. I was worried that they may think they're being sequestered or something like that.
Oh.
I don't know, just.
Get Sam. I didn't see that.
Okay, I'm just making sure that.
Do y'all have the feeling they would be sequestered?
Where is he going? He's just walking
Oh,
away.
9:30.
I just
Oh.
don't know, so I'm worried that they're going there.
Whatever. But 9:30, please, and let's get everything ready. So that charge is very standard. It's not a complicated punishment charge.
It shouldn't be judged.
No. So I'd like to anyway start at 9:30. So let's be here at 9 o'clock or a little bit earlier and let's get it all on the record and just continue with it and let's just go, okay?
Yes, sir.
Y'all have a good night. Y'all be safe.
Okay, so with that, yeah, okay. Bye, Denise. Enjoy your little trip to the store. Yeah, the jury was out for an hour. We came back with a verdict of guilty. Sorry, I got choked up just a second there. Yeah, some of that was hard. That was hard. That very ending, seeing that picture of her and stuff and him, that really choked me up. Wow. So tomorrow they'll be back for the punishment phase. They will go through and right onto it because we don't play around. So I will be back in a few hours. And I believe TCN might join me. And we're going to do the closing of Soto Escalera. I'm sorry, Jose Escalera. So that tongue, Sheila, make it work. Jose Soto Escalera. We'll watch the closing and the verdict on that. But I'm going to go take care of a few things before I do that. There's some stuff that I need to go do. So I will be back in a little while. I think I have it set up for 8 p.m. I have it set up for 8 p.m. I don't know. I need to see. Hio might go live earlier. And so I have to be there for Hio just because she's my right hand and I want to be there for her. So if she goes live at 7, which she might, I will change my live to a little bit later in the evening, but we'll see. Anyways, I don't mind. I'm here. I've got all night. So with that, I will see y'all later on tonight. And until then, y'all have a great rest of your evening. Peace.